Hi, everyone. Harry here to talk about a really interesting set of documents that now have been unsealed in the DC case involving January 6th and Trump's overall efforts post-election to steal the result from Biden. What we have here is the resolution of a 2-year battle by Politico magazine to get the court to unseal certain documents. And they have now unsealed those documents, though they remain heavily redacted to continue to maintain confidentiality of grand jury proceedings or protect certain witnesses' identities. We can pretty well piece together who's who, I think. But we're talking about some dozen or more documents in which the DC court had separate challenges by Trump or by witnesses. Trump saying there's executive privilege, these people can't testify, and the court going through the prescribed analysis for when executive privilege yields, what kind of executive privilege it is, basically the peek behind the curtain of what has been going on for a couple years. The first and most interesting point that emerges here is a repeated note of concern from the various judges doing these motions. And it's not just Chutkan, it's whoever was the motions judge or the chief judge at the time, Jeb Boasberg or Beryl Howe. They were the ones who would receive the motions by Trump or the witnesses because it had to do with the ongoing grand jury proceedings. And time after time, they rule against the witnesses and rule against Trump, but also make a point of the public need for speed here based on the electoral calendar. So we've had in the cases themselves in open public filings a kind of dancing around this issue. Jack Smith has never quite said you need to try the case by the day of the election so that the American electorate is informed. Trump has said things like you need not to because it will interfere with the election. Judge Chutkan has said you need to ignore the electoral calendar, but here you have something stronger. You have the judges in D.C. being aware that Trump is playing a delay game time after time after time in every way that he can, and their express recognition of the problem for that and how it is denying the public potentially the chance for information that they would receive if the case goes to trial by the time of the election in in next week. Now, when all is said and done, Trump won those battles with the very huge assist from the United States Supreme Court that grabbed the case away from the district court in order to consider the immunity question and then issue a very pro-Trump opinion that continues to cast a shadow on the case, but only a shadow. That is to say, if Trump loses the election, the case will go forward. It will be truncated because of immunity issues. It will be delayed while immunity issues are considered, but it still will happen. If Trump, on the other hand, wins, he can simply, as the head of the executive branch, just tell the DOJ, drop this case. And as he himself said, he has the extra measure cushion of protection from the Supreme Court's immunity decision. But we did not know until all these documents were released that the courts were focused on this and really concerned about it. They, as I say, sort of tiptoed around it in some of the main public filings. But you see from several judges and several witnesses a real recognition of what Trump is up to, namely trying to delay proceedings at every turn with the goal of keeping the important information that would otherwise emerge in the normal course of criminal proceedings about Trump's insurrectionary and otherwise obstructive conduct in the wake of the 2020 election and leading up to the whole constitutional crisis of January 6th and the assault on the Congress. So, over subsequent days, people will delve more deeply into each of these decisions and figure out what sort of nuggets there are to mine from them, but they are basically of a piece. You have witnesses being called to the grand jury. Trump and the witnesses perhaps coming to the district court and saying, quash this subpoena. I don't have to testify because of some claim of executive privilege. The D.C. court, often in the person of whoever is the Chief Justice at the time, be it Beryl Howe or Jeb Boasberg, going through it, saying, here is the privilege at issue. It is a limited privilege, as we know from our own precedent and from precedent of the U.S. Supreme Court, including in the Nixon case, that yields to a need for the evidence, going through the analysis of why there's a need for it, that itself being very illuminating in terms of showing where the case is going and what the sort of stress points are, and then generally ruling that the witnesses do have to go to the grand jury and testify. So that is the harvest that the political motion now has gotten, and a whole series of documents involving different witnesses. Again, they are heavily redacted, but still pretty illuminating. They would have been hugely illuminating, except for our having already received now a few weeks ago the Jack Smith brief explaining why and how he can go forward, notwithstanding the Supreme Court's immunity opinion, with various witnesses and going through chapter and verse. It's a similar kind of analysis that the district court does, but it serves it up straight, and it's to my mind, a pretty fascinating kind of pulling back of the curtain on what was going on. Again, with redactions, I don't want to oversell. If you go to these individual documents, you'll see redactions, but examination by commentators like me and others in the next several days will be able to get past at least some of those redactions and reveal what's there. But you'll see what's been happening before the Supreme Court took the immunity opinion and the various orders from district courts with long analyses of why the individual witnesses needed, in fact, to provide testimony to the grand jury. So really fills in quite a lot in the January 6th case, and also the claims of individual witnesses resisting, mainly without success, but there are some motions that do go Trump's way or the witness's way, but mainly you have the court saying, you got to testify, and here's why. And it tells you a lot about the case that is still alive and still coming in truncated form in the event that Trump loses. All bets, of course, are not only off, but extinguished if he wins, because the case will just be shut down. Okay, so lots of new good stuff there, and I would say maybe the headline is you see the court really focused on timing, knowing Trump's delay game, trying to push back against it, and that's all, of course, before the big intervention by the Supreme Court and the immunity opinion, which freezes everything for 9 months and gives him, in practical terms, the main victory he'd been seeking the whole time of delaying any trial until after an election and giving him the chance to scuttle the whole thing should he win. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.